Hello and welcome to the Kenneth for Cameron Law Office Legal Podcast. This edition we look at evictions and evicting deadbeat tenants who don't pay their rent. Now, it's always a better plan to have a written lease and to get a 1.5 month security deposit. If the tenant doesn't pay, although no notice is required to start the eviction proceedings, that's usually a better practice because you let the tenant know right away that you plan on bringing the action. It requires the preparation of a complaint. So as the attorney, we prepare the complaint. We attach any notices that have been sent based upon the unpaid rent. We need to prepare a summons. The summons has to set forth the phone numbers for legal services, the phone numbers for lawyer referral service, and some other housing department phone numbers. There's a filing fee. It's the summons, the complaint, the filing fee is sent to the Superior Court, Special Civil Part, Tenancy Division. Tenancy Division will then have a constable which has to personally go to the house or apartment. They have to serve the person or fix it to the door, and the court schedules a hearing typically within 3 weeks. On the day of the hearing, everyone's required to watch a video that explains landlord-tenant court. Then the judge does a speech, and then the team leader calls out the names on the calendar. If the tenant does not appear, a default is entered in favor of the landlord. The landlord then has to prepare a warrant for removal and a certification that the rent is still unpaid, and then pay a filing fee, and the constable will serve that warrant. If the tenant shows up, the question is for whether or not the tenant has the ability to pay any money. In many of our cases, we have and we entered into an agreement that's called a consent to stay, meaning that the tenant agrees in writing to pay a certain amount of rent by a certain time. If they don't, then the landlord can apply for the warrant for removal. If they if they do pay, they get to stay. Sometimes the tenant just says, "Listen, I need 2 more weeks and I will get out." Then there's a what's called a consent to vacate that has to go in front of the judge, and the judge has to explain to the tenant, you have to get out in those 2 weeks, and the judge signs it. Sometimes if parties can't come to any kind of agreement, then there's a trial. For more information on landlord-tenant law, visit website njlaws.com. And for representation, contact the law office of Kenneth for Cameron and Edison at 732-572-0500. Thank you.